My name is Rebecca Eisner. I'm a partner based here in Chicago in our business technology and sourcing group. I've also been part of our cybersecurity and data protection practice for many years now. And I also happen to be the partner in charge of the Chicago office. So, if you have any facility or operational suggestions for me, we'll take those today as well. I think that our topic today and in this panel is about some of the legal developments in cyber, and in particular we're going to focus on one aspect of cyber, which is personal data regulation. And Raj did a great job of setting up a framework in which we could think about some of the cyber challenges that we have in protecting our data assets. And he mentioned 4 key areas. For those of you who were taking good notes, you probably got these down. Of course, focus on boards, employees, procedures, and in particular the execution and implementation of procedures. And fourth, and probably most near and dear to the folks in this room, are vendor management. And we have increasing challenges with increasing regulation in this area, particularly not only around our protection of data assets, but in particular the protection and use of personal data. And so that's what our panelists are here today to discuss with us from 3 major regions of the world. I'm going to do our brief introductions here. First, to my left, I have Mark Prinsley. Mark is a partner in our BPS and IP practice based out of our London office. And he's regularly named as a leading individual in business process outsourcing, information technology, and IP by Chambers. And he acts for customers in all stages of outsourcing transactions. Next, in the middle, we have Gabriella Kennedy. Gabriella is a partner in our Hong Kong office, and she is also a member of our IP and our BTS and TMT, which is Technology, Media, and Telecoms, which is a phrase that's used a lot outside of the United States. So she's in those groups. She's a co-leader of the IP practice based out of Hong Kong, as I mentioned, and she advises extensively on technology and data protection issues in Hong Kong, as well as contracting with third parties. So welcome, Gabriella. And then last but not least, we have Lei Shen. Lei is a senior associate who acts like a partner and operates very much like a partner here in our Chicago BTS practice. And Lei has, in the past few years, had a specialty focusing on personal information, privacy, and cyber issues. Lei is a certified information privacy professional in the U.S. and a member of IAPP. So welcome to all of our panelists. And I'd like to ask, despite the great instructions that Brad gave this morning, we have so much content to get through on this panel. I'm going to ask you all to please hold your questions until the end. We are planning to leave time for questions at the end, and I believe that we go right into another break, so there should be plenty of time to get through your questions. With that, I'm going to turn it over to Mark to kick us off in Europe and talk about European development.
Thank you, Rebecca. It's great to be here, and it's great to be able to say, at long last, that we do have an adopted EU General Data Protection Regulation. So I can tell you what definitely is in it, and I can tell you when it comes into force, which is, that's not when it comes into force, in May 2018. So now is really a very good time to be preparing for it. I'm not a member of the Reduced Shakespeare Company who do 37 Shakespeare plays in 97 minutes. The regulation has got 173 recitals and 99 articles. I've got 8 minutes, so I have to pick some themes. And so the themes I've picked are the territorial application, increased compliance obligations, the sanctions for breach, which have been very heavily commented on, and then half a topic on international transfers, which is in itself a topic worth more discussion. So as far as territorial scope is concerned, there are 2 big things to realize. One, this is an attempt to harmonize law throughout the European Union. So the present situation is there is a directive which is adopted in slightly different ways in 28 countries, and it is a bit of a nightmare if you are implementing some data privacy project across the whole of the European Union at the moment, because although the general principles are the same, the flavors are slightly different. The harmonization and the way that the law is going to be implemented through a regulation rather than by national legislation means that the scope for national variation is dramatically minimized. There is still some scope for national variation, and one odd area is the protection of personal data of dead people is something that is going to be left to national governments to decide. So that's an important thing to realize, that life will get simpler when the law is harmonized. There are two big respects in which the law has moved on to take account of the fact that we live in a digital universe. First of all, the old or the current data privacy legislation in Europe works on the basis of we regulate stuff because actions happen in Europe. So if equipment is located in Europe, the European data privacy regulation applies. In a world of cloud-based computing, that is clearly not adequate. So now if you're based in Europe, if you're established in Europe, wherever you are processing personal data, and if you're using a cloud solution, you may have no idea where you're processing your personal data, you will be regulated by the EU data privacy regime. So that's a big change. The other big change in terms of global application is that if you are located outside the EU, so you don't even have an establishment in the EU, but you are targeting services at EU residents, or you are collecting data about EU residents, then you fall within the scope of the new global data protection regulation. And as an EU-based consumer, you might say, well, that seems completely fair. But if you're sitting here in the States or the Netherlands, Antilles, or wherever you might be, you might think that is a fairly significant change. It is a significant change, and you will be brought in to the scope of regulation. So what does regulation mean as far as the new law is concerned? Well, lots of the existing concepts will be tightened up, and it's kind of known as privacy by design and data minimization. The objectives are to stop people collecting data because it's nice to have. You've got to have data for a purpose, and you've got to explain why you've got it. You've got to justify it to yourself. There will be more sophisticated rules for the relationship between a data controller and a data processor. Under the current law, a data controller, the person who collects and makes decisions about how data is processed, is the sole person with obligations under the law. They have an obligation when they use a processor, somebody who is a sort of third-party contractor on their behalf, to make sure that there are certain protections in the contract with the processor, but the processor themselves has no direct obligations under the law. That is going to change, and processors will have certain obligations directly under the law just by virtue of them having processing activities. And so what is going to happen, and we are beginning to see this, is that the relationship between customers and suppliers, between controllers and processors, is one which is being looked at more carefully. And the processors are not so happy to take a general delegation of authority to process whatever data comes for whatever purposes, subject to agreed security standards. They want to know much more specifically what their obligations are, and that is, I think, because they are getting concerned about having direct obligations under the law. There are going to be more specific record-keeping obligations on both controllers and processors. That probably not significant, but it is part of the increased obligation on the data processor. There are going to be, if you're involved in high-risk data processing, so automated processing of personal data, making decisions about people through automated means using artificial intelligence solutions, then there are going to be additional protections in the law. You're going to have to do things called data privacy impact assessments to make sure that you are minimizing the risk to the individuals. Another compliance concern is that certain organizations are going to have to appoint specific data privacy officers who are to have kind of independent roles to regulate how a business looks after personal data. In fact, that's probably a less frightening obligation than seemed to be the case when the regulation was being debated. Compliance obligations are really only one side of it. What really happened is the law is giving, the new law will give data subjects much greater rights. So the individuals whose data is being collected will have much greater rights. So they're going to have, there's going to have to be much greater transparency about processing. So again, you've got to have more certainty about what people are doing with their personal data, and it's likely that this has got to be explained in very simple terms, like in Europe at least we have instructions on clothes about what you can do when you put things in a tumble dryer and that sort of, and I imagine you've got the same in the States, and those kind of icons are what are going to have to appear. Data subjects are going to have a right to be forgotten, which is that data's got to be removed from servers when they don't want to have it disclosed more publicly. There to be data portability, and that I think is quite important in big data type solutions where people have given people data, they're entitled to have that data taken away and moved to an alternative supplier. So if you've got a mortgage with someone, you could have all your mortgage records moved to someone else. Online, if you're a mobile phone provider, you might be faced with having to transfer mobile phone records to a new provider. That's a right that data subjects are going to have. There has been a very convenient way for processing personal data under the data privacy legislation in Europe, which is, you can say, it's been in my legitimate interests and the data subject suffers no loss. Well, that broad right is going to be cut back because a data subject can challenge that. And the data controller's got to show, now going to have to show compelling reasons why it is in their legitimate interests to process personal data. So again, this is a kind of pressure to be more focused on why people are processing personal data. Data minimization is this kind of the watchword. The big thing that's had lots of comment is what happens about data breaches. So in Europe, we haven't really had a statutory data breach legislation. This is going to introduce statutory data breach notifications. You're going to have to notify the local information commissioner within 72 hours unless you can show compelling reasons, and you may have obligations to notify the data subjects. And the data processors are going to have obligations to notify the data controllers about breaches. So there's an answer to a question that somebody raised earlier about whether the processors are going to have obligations to tell the controllers. They are. The headline is that if you screw things up, you're subject to an administrative fine of up to 4% of worldwide turnover. That is not the case in Denmark and Estonia, where you can't have administrative fines. So it might be possible that to see a growth in some kind of data processing businesses in Estonia and Denmark as a result of the new law. There's greater clarity about individuals having direct rights of action, and there are greater abilities for consumers associations and trade associations to bring claims on behalf of individuals, dealing with Raj's point about how, in some cases, the loss an individual might have suffered from a data breach is so trivial that it isn't worth bringing an action, but collectively it is. And international transfers, be of interest. It's the same old story, same routes are available, but that's only half the story. I'll hand over now, I think.
Oh, I have a question.
Oh, you have a question? Oh,
yeah.
right.
So the 4% number is quite scary, and we have about a little less than 2 years now when the new regulation takes effect,
yes.
correct? So what can our clients be doing right now to start preparing for compliance with GDPR?
So I think the obvious thing is to be looking at the relationships with third parties and making sure that where you've got third parties processing personal data on your behalf, you can tick all the boxes about what you are saying the third party is processing the personal data for, how long they're keeping it for, and who they're giving it to. All those kind of simple things, I think, people have very complicated webs of data processing, and now is not too soon to be looking at all that kind of stuff. The more lateral idea would be, I think, to start thinking about creating a code of practice with other people in similar industries about how you're going to handle personal data in your industry, because the 4% fine gets discounted if you've been complying with an industry code of practice about how you handle personal data. So if you might even want to take the lead in creating a code of practice amongst your peers about how an industry, say the airline industry, handles personal data. And then if you've complied with that, you will get a discount on a fine. I think the 4% figure is a real headline, and you should really be thinking more realistically about if this makes any big difference to you, 2%. But,
all right. Thank you, Mark. Gabriella, we tend to talk about Asia as being somewhat monolithic, but of course it is not, and there are many, many developments and changes going on in Asia. So talk to us a little bit about what you're seeing there, please.
So good morning, everyone. If Mark said that he felt like he was the reduced Shakespeare company, I feel like I've got Mission Impossible here. And typically, I'm asked to talk about Asia in 10 minutes. I thought that rather than have slides, I would have heat maps for you today. I'll start with just picking some of the differences for you to get an idea how difficult the life of a privacy practitioner it is in Asia when clients come and say, I would like to implement a clear plan that will see me throughout the whole of Asia. So, as you can see in that heat map that I put as my first slide, you have a couple of countries that have got overarching legislation. There's, and I don't have on the slide, Australia, New Zealand, Hong Kong, Malaysia, the Philippines, Taiwan, Japan, and South Korea. Of those, Hong Kong is one of the oldest, bar New Zealand and Australia. We've had legislation since '95, so nearly 21 years into it, we're looking at changing it again. We changed it in 2012. Recent additions are Malaysia and Singapore. The Philippines has just started the implementation, and they've got a first investigation on their hands because they've had a major hack of an electoral system, and the newly appointed Data Privacy Authority is dealing with it right now. It's interesting to see what brought about the development of legislation in Asia. When people ask me what I think about them, I say the legislation is truly provincial. Okay, so every single one of them is influenced by different cultural factors, by different economic drivers, and by particular incidents that have happened. I'll give you a simple example. In Hong Kong, we changed the legislation because we had a major data leak involving a stored value card. It's like the Oyster card, it's the octopus card we have in Hong Kong, which, by the way, predates the Oyster card, and you can use to go all the way to China to buy things in utilities, in convenience stores. The leakage of that, the breach brought about very strict direct marketing provisions that you find nowhere else in Asia, so no other reason for it. You have a couple of jurisdictions that actually have adopted for a more relaxed approach to data protection, and they embrace accountability. So we've moved on in some jurisdictions from compliance to accountability, and these would be typically the jurisdictions where they're very keen to develop an ecosystem of data centers and data processing. So these would be Singapore, Japan, and the Philippines. And interestingly enough, in those jurisdictions, they've actually carved out exemptions for data processors. Okay, so the Philippines is one such example, Singapore as well. The other differences that I wanted to flag, if you just look at the enforcement and the level of fines, they vary significantly. Hong Kong is regarded as being a very sophisticated regime, and yet our fines are quite low, so the legislation doesn't have teeth. You really have to be really, really, really bad for the regulator to come after you and impose a fine of no more maximum, but we have never had it, of about $60,000 US. Now compare that to Singapore, where the maximum fine is $800,000 US, and compare that with China, which is yellow. There's no overarching legislation, yet you have piecemeal legislation that gives you a headache just reading just the pieces of legislation. But the serious thing that can happen to you if you don't comply, let's say, with the data localization laws, which are really, really tough, is the revocation of your license, of your business license. So you will sit up and listen when that might be the consequence. India is similar, where you actually, as a data processor, you have obligations vis-a-vis the security of the data, and you can face a fine of about $1 million US. There are also differences in respect of whether or not the legislation and the regime is consent-based or notification-based, okay? So there are, differences. New Zealand and Hong Kong are notification. Many of the others are consent. So New Zealand and Hong Kong, you only need consent if you've changed the purpose. So these would be just sort of some of the big-ticket, changes. Sorry, is it down?
Yes, no.
That one. Data localization is one that gets everybody excited, and in China in the last year we've had 4 pieces of legislation: the national security law, the cybersecurity law, and the anti-terrorism law, all of which pretty much talked about keeping the data within the Chinese borders. But this is not anything new, because if you're in the financial sector, you already had an obligation to keep everything that you are collecting in China inside China. What these new pieces of legislation introduce is actually perhaps an opportunity to take the data out, but at a particular cost, and the cost is providing a backdoor or discussing with the authorities the plans that you have and showing them quite a lot of the data that you have collected. So that scares a lot of people. We have stringent data localization restrictions on the horizon for Indonesia, where we don't have legislation, but there's a draft out there. So there's an opportunity for anybody who wants to do lobbying to get involved now. Cross-border data transfer restrictions are interesting. In Hong Kong, which is one of the oldest regimes, we have a provision that talks about cross-border data transfers, but we never actually brought it into force. We had a guidance note that was issued at the end of 2014, where the regulator was looking at drawing up a white list of countries that might have equivalent regime. That is sounds a little bit like what is happening in the EU. And by the way, does anybody know how many countries in Asia have been considered and held as adequate by the EU? Because we're talking about what is happening with data transfers between the US and the EU, but nobody really talks about how do we deal with data transfers to Asia? And there's a huge center of power, economic power now happening in Asia. So do we know how many countries are considered adequate? And that is? New Zealand. And why is New Zealand considered as having an adequate protection system? Because they changed their legislation a couple of years ago, and to satisfy the EU that if data is in transit or comes from a third-party country into New Zealand, gets processed and then out, they will deal with it, and they will impose certain obligations on the people who are doing the processing. Nobody else in Asia does it. Yet there are regimes in Malaysia and in Macau, for example, that are closer to the EU regime in terms of the provisions that they have. So quite a few countries don't have, data transfer provisions in force. Japan is looking at introducing something that they're revising the legislation. So I did say that there is so much happening in Asia. In fact, I've got somebody in our office who does nothing else but track the changes in data privacy and cybersecurity on a weekly basis, because it's extraordinary the number of changes that we're seeing. So already we know that Taiwan is revising the law. Japan has already revised the law, and there will be new provisions coming in the autumn. Korea is doing the same, new provisions coming in autumn, new provisions in particular in relation to data processing that make it stricter. Korea, by the way, is considered by many to be the strictest regime in Asia. And the reason for it, this is the country that has the fastest broadband in the world. It's the country where there is the highest incidence of identity theft. It's the country where 20 million pieces of data of credit card holders were stolen, including the credit card data of the president of the country. So you can see that when that legislation came in, they were very, very keen to make it very strict. In essence, in Korea, if you need to do anything with the data, you need specific consent, and you cannot get broad consent. You cannot get a bucket and say, I'm going to list everything. It's got to be specific for absolutely everything. Other interesting and unusual provisions vis-a-vis extraterritoriality, I'm going to mention two countries, and those are the Philippines and Australia. Australia and the Philippines have provisions, unlike the EU, which says if you're collecting information about EU citizens, EU law is going to apply. Philippines and Australia say, if you're collecting information about my citizens, wherever you are in the world, my legislation, I'm going to look after, my citizens in that particular jurisdiction. I don't know how they're going to manage to do it, but it's interesting that they are attempting it. Direct marketing restrictions, I mentioned that these are things that have preoccupied quite a few of the Asian regulators. And I'll finish up, because I know I've got 1 minute, on where we see developments in Asia. Cybersecurity is big in Asia. So in Hong Kong, we've just had guidance notes and circulars issued, and interestingly, the semantic focus changing from just guidance and caution to really mandatory provisions on financial institutions. We've had a Cybersecurity Fortification Initiative, it's called, which really requires financial institutions to do an impact assessment, to put in place a very strong security measures, and it also mandates the training of cybersecurity professionals in conjunction with a third-party provider, and this is going to be taken care of by the financial regulators. So I think I finished right on time.
Thank you. Thanks, Gabriella. So one question for you. We have some clients who have operations in these territories and, of course, are collecting information from the residents right in those countries, but we also have a lot of clients who are just doing deals with providers who maybe have operations, so they're not collecting data of their own people in the Philippines or India or China, for example, but yet these are outsourcing destinations either for the contractors or the subcontractors of them. And can you share with us a little bit of to what extent, if you don't have operations in those countries, but you are outsourcing to a provider that's, say, doing something in the Philippines or India, to what extent do they need to worry about data transfers of their data into those countries?
Okay, so it depends on the country. So as I was mentioning, there are countries that are very protective of their BPO business. So there's Singapore and the Philippines who have carved out an obligation on the data processor to do anything with that data bar security and data transfer. If they themselves transfer it out again, they would have an obligation vis-a-vis the regulator. Others that are silent about it, so they don't tell you anything. So Hong Kong does not tell you anything, but interestingly in Hong Kong we don't regulate the data processor. So the obligation and the test will be, is there control over that data in the jurisdiction? It does not matter whether you have a server, whether you have whatever operations you have. The test is always, do you exercise control? And that is measured by different factors. You know, do you have you got a right to manipulate the data, to change it, to require the consent, to notify people?
Okay. All right. Thanks. Leigh's going to tell us now about recent developments in the U.S.
All right, there have obviously been a lot of privacy developments in the United States this past year, including the ones that Raj mentioned in his presentation earlier. In the interest of time, I'll be focusing on two key developments: updates to the state data breach notification laws in the past year, and the recent rejection of the Privacy Shield framework. So first, we'll cover state data breach notification laws, which, as you're probably well aware, are constantly being amended. In this past year alone, several states updated their law, 13 in 2015 and 6 so far in 2016. The main changes to the various state data breach notification laws this year have generally fallen into 4 buckets: expansion of the definition of personal data, encryption exceptions and requirements, notification timeframes, and requirements for the contents of breach notices. So first, several states expanded their laws' definitions of personal data this past year to increase their scope. As many of you know, the definition of personal data under the state data breach notification laws is much narrower than that under the EU Data Protection Directive. The EU Data Protection Directive defines personal data as any information relating to an identified or identifiable individual, whereas generally the state data breach notification laws only cover data elements that may make an individual vulnerable to identity theft or credit card theft, such as name plus social security number, driver's license and state ID number, or a financial account number or credit card number with a PIN or other security code. So increasingly, particularly in the past couple of years, states are adding additional elements to the scope of these laws, most commonly medical information, biometric data, and a username or email address in combination with a password or security question and answer. For example, Montana and Oregon recently brought in their laws to include medical information, and Rhode Island and Illinois recently expanded their laws to cover an email address and password. There are a few outliers, of course. California, surprise, now includes data collected by an automated license plate recognition system. North Dakota recently expanded its definition to include a work ID number in combination with a security or access code. And Wyoming recently expanded its definition to include a birth or marriage certificate. So to cover these revisions in your vendor contracts, you should make sure the definition of personal data is not limited to a specific set of data elements, but rather have a definition that includes any information relating to an identified or identifiable individual to cover EU and similar data protection laws, as well as any data that is otherwise subject to data protection laws, to cover these odd elements that are covered under U.S. data breach notification laws and other laws that have a very similar narrow scope. The second bucket of changes covers encryption exceptions and requirements. Most of the state data breach notification laws exclude encrypted data from scope, but do not define what encrypted actually means. A few states have started to change that. California, for example, recently revised its law to clarify that encrypted means rendered unusable, unreadable, or indecipherable to an unauthorized person through a security technology or methodology generally accepted in the field of information security. A few states also specify minimum encryption requirements, joining Nevada, Rhode Island, for example, now requires 128-bit or higher encryption in order for the data to be considered encrypted data. Similarly, Washington recently added that to be considered encrypted data, the encryption must meet or exceed the NIST standard or otherwise modify personal data so that it is rendered unreadable, unusable, or undecipherable by an unauthorized person. A number of states, including Illinois and Nebraska, now state that the encryption safe harbor no longer applies if the encryption code is also compromised along with the encrypted data. The most important change, though, comes from Tennessee, which now requires notification of a breach regardless of whether that data was encrypted, basically removing the encryption safe harbor altogether, the first state to do so. So to address these changes in your vendor agreements, you should make sure that you specify certain minimum requirements for encryption rather than leaving it undefined, and also ensure that the vendor is required to notify for any breaches of personal data, regardless of whether or not it was encrypted. The third bucket of changes covers notification timeframes. Rhode Island and Washington both recently amended their laws to require a 45-day deadline to notify individuals after discovery of a breach, joining a handful of states, including Ohio and Wisconsin, that have specific notification timeframes other than expediently or without unreasonable delay. The fastest notification timeframe, though, is still Florida, which requires notification to individuals within 30 days after discovery of a breach. It's important to note, though, that these notification timeframes are for data owner and not for data processor. As many of you know, the state data breach notification laws also contain requirements for data processors, such as a subcontractor, to notify the data owner in the event of a breach. These notification timeframes are often much shorter. Most of these laws require a data processor to notify a data owner immediately or without unreasonable delay following discovery of a breach, but Georgia does require a data processor to notify the data owner within 24 hours. And the fourth bucket of changes covers requirements to contents of breach notices, and these are mainly the recent changes to California and Illinois laws. California now requires the use of certain uniform language in breach notices. Specifically, the notice must be titled Notice of Data Breach and must be organized using certain headings, specifically what happened, what information was involved, what we are doing, what you can do, and for more information. The law requires other specific elements in the notice, including that the text cannot be smaller than 10-point font, and permits additional information to be provided as a supplement to the notice. Illinois also recently amended its law to require the breach notice to include certain information. Specifically, if a breach involved an online account, the notice must direct affected individuals to promptly change his username or password and security question or answer, and to take other steps that are appropriate to protect all of his online accounts with the same username and email address. The next development we'll cover is the rejection of the Privacy Shield framework. Now, the Safe Harbor framework was a mechanism that allowed personal data to be transferred from the EU to the U.S., since the EU considers the U.S. to be a country with inadequate data protection laws. The Safe Harbor was challenged by Max Schrems in the Irish courts and was subsequently invalidated by the Court of Justice of the European Union in October 2015. Specifically, the court said that the Safe Harbor was invalid because the Safe Harbor principles were subject to national security and law enforcement exceptions, which undermined EU citizens' rights to privacy and judicial protection. This invalidation effectively removed the transfer mechanism for about 4,500 U.S. companies that were Safe Harbor certified at the time. The U.S. and the European Commission then negotiated and proposed the Privacy Shield framework as a potential successor to the Safe Harbor, and referred the framework to the Article 29 Working Party, which is made up of European data protection authorities, for its review. In April, the Article 29 Working Party issued its non-binding opinion that rejected the Privacy Shield framework. It criticized certain elements of the Privacy Shield and determined that the Privacy Shield did not offer a level of protection for EU citizens in the U.S. that was essentially equivalent to the protection given in the EU. Since then, other European regulatory bodies have also raised similar concerns about the Privacy Shield. For example, the European Parliament recently passed a resolution recommending that the European Commission and the U.S. renegotiate the Privacy Shield to address certain deficiencies. Specifically, the European Parliament voiced concerns about the ability of the U.S. law enforcement to access personal data transferred from the EU, and that the bulk data collection in the U.S. would violate certain requirements set forth in the EU Charter of Fundamental Rights. In addition, the European Data Protection Supervisor recently raised similar concerns about the Privacy Shield. The supervisor claimed, in his opinion, that although the Privacy Shield was a step in the right direction, it was not robust enough to withstand future legal scrutiny. And while all of these opinions are not binding, they are still highly influential.
So, Lei, so we had Safe Harbor, that was invalidated. We then all breathed a sigh of relief here when Privacy Shield became available, but then there were questions and challenges which make Privacy Shield a risky mechanism to rely on for transferring data from Europe to the U.S. And we should clarify that when we're talking about transferring data, it's not just third-party data, it's your own affiliated company data. So if you have affiliates in Europe who need to get your company's data over to the U.S., you need an approved means for doing that. But it seems like there are none. So how are we currently getting data out of Europe to the U.S.?
Sure. So there's a few other means available for a company to transfer data out of the EU into the U.S., especially in light of the uncertainty regarding the Privacy Shield. But first, before we cover those, it's important to note that both the Safe Harbor, when it was in effect, and the Privacy Shield only apply to transfers from the EU to the U.S. They don't apply to data transfers from the EU to other countries. For those data transfers, there's always been some approved method of transfer. So what are those other approved methods of transferring data out of the EU? Well, first, there's the EU model clauses. There are 3 variations of these, 2 covering a transfer from an EU data controller to a non-EU data controller, and 1 covering a transfer from an EU data controller to a non-EU data processor. Entering into these model clauses are the most commonly used mechanisms for transferring data out of the EU, especially since the invalidation of the Safe Harbor. And they apply not only to transfers from the EU to the U.S., but also from the EU to other countries. They're relatively easy to put in place and can't be modified through negotiation. But we flagged here that the use of model clauses should be used with caution because its validity was recently challenged under the same grounds that that invalidated the Safe Harbor framework, which is the potential for U.S. government surveillance is not prevented by use of this transfer mechanism. The Irish Data Protection Commissioner recently announced that it will ask the Court of Justice of the European Union to determine if multinational companies can continue using the model clauses to transfer data between the U.S. and the EU. If the model clauses are found to be invalid, then unfortunately, in the absence of Privacy Shield, many companies would not have a practical or easy method to transfer personal data from the U.S. to the EU. In addition, it's unclear whether the challenge to the model clauses relates solely to the transfer of personal data from the EU to the U.S., or if it also covers all transfers of personal data from the EU to any country that the EU considers to be inadequate. The second transfer mechanism is the BCRs, or binding corporate rules. These are a set of intercompany agreements, policies, and principles that apply to affiliated companies that wish to transfer data to each other. BCRs are very useful for sharing information within a corporate group. However, the process to obtain BCRs is long, complex, and costly. Another major drawback with BCRs is that they are only for transfers within a family of companies, so they don't cover transfers to a company's third-party data processors. They may also potentially carry the same risk as the model clauses, since the same reasons for the invalidation of the Safe Harbor also apply to the BCRs as they did to the model clauses. However, at least for the time being, the chairwoman of the Article 29 Working Party has confirmed that the data transfers may still occur under the BCRs and model clauses. The third transfer mechanism that you can use is the list of derogations listed in Article 26 of the EU Data Protection Directive. Derogations are specific exceptions that permit data transfers. Derogations, however, are not interpreted as broadly as one might hope, and so reliance on them as a means of transfer does carry some risk. The most commonly used of these derogations is the unambiguous consent, where the data subject to the proposed transfer gives its consent, which may be useful in situations where it is not challenging to obtain consent from an individual. However, there are many situations where this is not a practical solution. In addition, the EU data protection authorities have varying views on what constitutes valid consent from an individual and have been especially reluctant to accept valid consent as a data transfer mechanism for ongoing and systematic data transfers. There are also concerns around the ability to obtain consent from individuals since consent must be freely given. So there are various challenges that exist with the idea of using data subject consent as a means for data transfer. A fourth transfer mechanism is to obtain approval from a data protection authority for a company's data transfers. However, this can be very time-consuming and not a very efficient means of conducting a data transfer. Lastly, companies can consider whether they can provide their services from within the EU or without transferring personal data outside of the EU. While this isn't really a transfer mechanism, a number of companies have started using this method since it helps avoid a lot of the uncertainty that's currently involved in some of these mechanisms.
Okay, thank you, Lei. We have about 10 minutes left. Any questions from our audience? I have one then, of course. And this is for a combination of Mark and Lei, really. So, Lei, you mentioned that getting the standard contract clauses put in place as an approved means of transfer is relatively easy to do. And I think that it's somewhat easy because if you're using a controller to processor set of clauses, they can't be modified, so your data processor, your outsourcer who you're using can't really push back and try to negotiate the clauses or make modifications. That part makes it simple. But for many of our clients who have multiple entities who are then transferring to a data processor or even a data processor that might be using its own affiliates to serve it around the world, it can get a little complicated. So Mark, can you speak a little bit to the complication that you encounter in using model clauses, because in some jurisdictions they need to be filed?
Yeah, so there are a couple of problems with the model terms. First of all, it's a bilateral contract. So if you're a group of companies, you've got to have a bilateral agreement with each member of the group. So it soon becomes a complex thing to manage. And as Rebecca said, in some jurisdictions, it's quite permissive, the UK being one where you simply have to sign the model terms and file it and produce it as and when required. And in other countries, you have to not only notify the local regulator that you've put in place a model term solution. In some countries, you have to wait for the approval of the local regulator to those model terms. And across the 28 countries in Europe, there are many different practices for what would appear to be an approved solution applicable across Europe. So it is not a walk in the park putting in place these model terms across the whole of Europe.
Lei, has that been your experience?
Right. Usually if there's been,
You can use your mic. Oh, yeah.
I don't have a mic.
Go ahead.
Do you want mine?
Usually we've seen companies entering into intergroup agreements if they have to transfer data amongst a lot of different entities within their group of companies, and they haven't entered into binding corporate rules yet.
So you're all involved in negotiating contracts on behalf of clients like we have in the room today with third-party outsourcers, and it seems that this area is incredibly difficult to negotiate provisions on. The contractors or the outsourcers are trying to push risk back over to the client side. You can understand why, that the change is happening so rapidly here. They don't really know what to expect. In some cases, the laws primarily still apply to the data controller or the client that is gathering the data, not the processor. So what are you experiencing, and what are some of the suggestions you might have for our clients about how to approach some of these issues, the risk allocation or the difficult contract provisions that the negotiations that we go through?
I'll jump in because it depends on the jurisdiction where you're operating. So you have certain places where you have the other regulators imposing outsourcing obligations. So I'm looking at the financial sector. They have outsourcing guidelines which you can really show to your service providers and say, there's not much I can do because my license is at risk here. You've got to give me those, indemnities. You've got to give me the assurance that is needed and is required for me as somebody who operates in a regulated industry.
So I would say in a recent cloud negotiation we've had with a major cloud provider, we got the cloud provider to agree to put the data in Europe. So for key jurisdictions, for key applications, there was just no debate. The data is going to be hosted in Europe, despite the fact it's a cloud and in theory nobody knows where the stuff is. And that way you get round the data transfer rules. So that's something that's happening. There is a trade-off as well because, of course, the people who you think are data processors are actually acquiring a lot of information through their processing activities, which is of value to them, and you mustn't discount the bargaining position you have in allowing the processor to use aggregated data in order to improve the offering to others. So you're not in a no negotiating position, but it's tricky.
And the number one question we tend to get asked by clients when we have discussions or presentations like this is, what is the amount of liability that we're seeing outsourcers be willing to take here, whether it's cloud providers or, more traditional outsourcing providers, or even some of the new emerging tech providers. How much liability are we seeing people being willing to take? I don't know if maybe, Lei, you can start with what we're seeing in that area.
Yeah. We're increasingly seeing more providers try to limit their liability. It used to be unlimited liability for breaches of confidential information and personal information, but now increasingly providers are trying to limit what they're liable for. We're putting into contracts that providers need to at least cover the cost of notifying individuals, notifying agencies, and other similar costs. Credit monitoring costs, but know that it's no longer unlimited, unfortunately.
Gabriella, what's your experience been?
Pretty much the same. I mean, if you're lucky, you can get them to the value of the contract, but unlikely.
So I've got a slight variation on that theme, which is when you're in a regulated sector, we have seen really quite significant, but caps on that. It's not unlimited, but pretty significant caps.
Significant meaning higher than you would expect,
yeah, significant
not
being a very big number, but a fixed, but a very big number, because that is the only way that they can persuade the customer that their regulatory concerns are satisfied. So I think it does depend. If you're not in a regulated sector, I think it's much harder.
Okay. And I think it's worth mentioning that even with a cap on regular damages, we still see the carve-outs and exceptions for things like gross negligence, willful misconduct, that kind of egregious behavior being carved out from the limitations of liability. But of course, those are very high standards to meet, and so it can be difficult to fit your facts into that circumstance. So, well, I want to thank our panelists very much for their time and their wisdom today, and they will all be around for discussions during the lunch break. Thank you.